Malcolm Mercer is a partner with McCarthy Tetro. He is a long-serving bencher and has suffered through various different committees, and he's currently the chair of the, Professional Regulation Committee?
Vice chair of that.
Well, that's what your website says.
Oh, well, so it's wrong.
All right, thanks, Malcolm. He's going to talk to us about contingency fees.
So my website shows the problem with advertising and marketing and deceptive practices. So I'm here as the chair of the excitingly named Advertising and Fee Arrangements Working Group. We started our work, I guess it must be close to 2 years ago, and we started with a quiet consultation of stakeholders and interested parties, almost in a focus group approach. We had conversations without sort of broadly stating where we wanted to go, because we didn't know where we wanted to go. We wanted to assess the environment and the problems. As a result of that, in the spring of 2016, we released a report and a call for consultation, and we received substantial input from the professions, from others, in the early fall up to October of 2016. Since then, we've released 6 reports and 2 major sets of reforms within the rules of professional conduct. The first related to advertising and to deal with what was broadly seen as deceptive, misleading, problematic, unprofessional advertising, and we revised the rules substantially in February. In April, we made revisions to deal with referral fees, which, as a practical matter, had escalated from traditional referral fees, which were not raising problems, to very substantial referral fees, including upfront fixed referral fees, which were at risk of increasing the price ultimately charged to injured people, at risk of causing referrals to be made not on the basis of expertise but on the basis of price, and were fueling what we thought was a problematic way of practice. So we addressed that in April. We then turned to contingent fees, and after discussion realized or concluded that we needed further input, and so we again called for input in June of 2017, which was effectively the 3rd consultation round. That completed at the end of September. We've spent October and early November dealing with that input, but also dealing with the broad recognition in the press, or broad indication in the press, that there are problems with respect to the contingent fee system. We also worked in the context of the Marshall Report, which is focused on the insurance side of the motor vehicle personal injury world, and the report from Mr. Marshall, which came out in the spring, in April. There is undoubtedly significant public and political pressure in the context that we have worked. What we have done, though, is not to cave or to cater to political pressure, but to recognize that there is a need for reform and a need that we act on a policy basis to come forward with reforms. The 7th report of the working group will come to convocation in December. It is not yet released, and I'm giving you a preview. I know this is a perfectly safe room to say anything and it'll go nowhere, but I would ask you to honor that as best you can, because this is a report before it's a report publicly. The key recommendations that we will make are driven off the Court of Appeals decision in 2002, McIntyre, which originally allowed contingent fees. Until then, they were prohibited as a matter of Ontario law. The Court of Appeal said that contingent fees were important for access to justice, but contingent fees had to be fair and they had to be reasonable, otherwise they remained unlawful. The Court of Appeal, in a subsequent decision later in 2002, Raphael Partners, elaborated what that meant. They said that fair looked at whether or not the original agreement was transparent, understood by the client, entered into in a proper process. Reasonable meant after the fact, looking back, did the fee that was charged make sense, taking into account risk, taking into account cost, taking into account complexity, taking into account investment. We may wish that we lived in a perfectly competitive market where we didn't have retrospective reasonableness review, but that is the law in Ontario. So what we've done in the context is to try to, instead of doing what some would have us do, which is to have caps on contingent fees as a way of dealing with excessive contingent fees, and there is significant pressure, as you'll know, from insurers, from some politicians to go there. What we've instead done is focus on transparency and openness as opposed to caps. The key reforms that we will propose are first, at the front end, as a matter of fairness, a requirement for a standard contingent fee agreement. It's clear and I think broadly accepted that people don't understand what they're entering into. It's simply too complex and it doesn't work. We will require or propose that it be required that there be a document provided, much like in the referral fee context, which allows potential clients to know their rights so that they have something clearly in front of them. Up to now, I suspect nobody in the room would have any anxiety about either of these. The thing which we will propose in addition, which some will disagree with, is that people who are looking to hire lawyers on a contingent fee basis have publicly available the maximum percentage that the lawyer charges. We see that as being salutary in that it provides market information and it allows scrutiny of those who are simply charging unreasonable amounts. You could describe it as a personal cap, in effect chosen based on the area of practice, the nature of the work being done, and it simply is a matter of disclosure. You can choose it. There are other ways we could have come at it. We think that there isn't sufficient market information for people to make choices. I know many will disagree with that. We had lots of debate as to how to better inform the market. At the back end, when reasonableness is the issue, where it's necessary to determine whether in retrospect the fee is reasonable, and recognizing that's really hard because it's hard to assess risk at the back end when there isn't risk anymore. There's a problem intellectually in doing that well, but this is the nature of the beast. So we are proposing three things. First, a clear breakdown of the numbers. We need to have clarity so that clients understand what was recovered, what went to disbursements, what went to the lawyer, what goes to them based on the fee that's charged. Nobody should have difficulty with that. We'll propose requiring that clients be advised of their right of assessment. Some will have trouble with that, but we think transparency demands that clients know their rights. The last is that we think that, and propose that, a client should have the same information that the Court of Appeal and Raphael Partners said was required to assess reasonableness. If the court requires information, we say, why should the client not have that information, and why should it not be given to them automatically? And so we will propose that the ultimate report or ultimate account make disclosure in accordance with the Raphael factors. Finally, there is much that is rightly said about our lack of information, and we've had submissions, interestingly, both from the Trial Lawyers Association and from the insurers, saying that there should be better data gathering. It's almost ironic when you have those two groups submitting the same thing. It makes you scratch your head a bit. But nonetheless, we think they're right. And so what we will be proposing is that lawyers who charge contingent fees will be required annually to report their average, the total of all of the fees, contingent fees received against the total against which it was calculated, preferably broken down by area because we know different areas have different risks and therefore get different contingent fees. But what we would then do is take that information and aggregate it so that we could say province-wide, this is what on average is being charged for motor vehicle personal injury. This is on average which is being charged for employment litigation. We think there are two advantages to that. One, it informs potential clients and it informs lawyers what people are doing generally. And that doesn't require you to do anything. It's not a cap, it's not mandatory, it's simply information. And the second is that it informs policymakers. It informs policymakers what looks unusual, and it allows some understanding of what the cost to injured people is in Ontario for obtaining the legal assistance that they need. You should be clear that we recognize that access to justice depends on contingent fees. We know absolutely that injured people can't afford the assistance they need unless and until they recover. And that's why we are opposed to caps. We think caps will cause not the reduction of fees, but the reduction of claims. We are concerned that the net effect of not funding litigation is that there wouldn't be litigation. So that's our fundamental premise. We want access to justice, we want a contingent fee system that allows it, and we want transparency that makes it fair. That is my report.
Okay. Would you be willing to answer a couple questions?
Of course.
Again, for first-timers, there's a couple of mics that are set up in the room. If you have any questions at any time and you want to go up to one of the microphones, make sure you identify yourself and your association so that we can keep it clear. I had a question about the reporting of the averages. Is there going to be any reporting required of lawyers to report the losses that they suffer? In the sense of the contingency fees, you're talking about the ones where they get something, and I'm concerned about those cases that aren't being reported where the lawyer has financed the entire matter and loses.
Yeah, I'd love to go there. I think it would be great if there's support for it, that we have reporting what I've described in an article that you may have read as the portfolio, so that we understand not just the economics of the winners, but the economics of the losers in the entire portfolio. If there, we tried actually to be minimalistic to the extent we could. I think that's a great idea if there's support for it.
Anyone have any questions? I know it's fresh off the presses, so you may not have had a chance to formulate any questions.
To be clear, it's not even off the presses.
That's true. That's true. Oh, just a second. Can you guess what area of practice Mike Winward and I practice in?
Morning, Malcolm, and thanks for coming.
Good morning.
I know in the working group initial paper you were talking about, or you were looking at the idea of, with all-inclusive settlements, taking the settlement amount and the costs, and then you would charge a percentage of that. Is your group continuing on with that thought?
Yes, and sorry, I should have elaborated that. That was the fourth thing, and I stopped at the third thing. We do recommend that the Solicitors Act be amended so that costs as negotiated or fixed can be included in the total amount against which a percentage is charged. We think it's insidious in the settlement stage where nobody's fixing costs that the lawyer say this is cost, this isn't cost. It creates an inherent conflict of interest. We think it's insidious if the lawyer is negotiating with the insurer as to damages separate with costs, that it creates a conflicting self-interest. We think the right answer is simply to put everything into one number so that there isn't that insidious cross-negotiation. What we also think, though, is that where matters are ultimately adjudicated and costs are assessed, then we think that the lawyer should have the option of being able to charge a fee on a full indemnity basis premised on the fixed cost after an adversarial process. In that way, the conflict is gone, and it allows funding of lower value or higher risk cases, but at no cost or at minimal cost to the client, because the client will get the compensatory recovery or the damages recovery to which the client's entitled, and the lawyer won't get any more than full indemnity costs fairly assessed. So thank you for that. I do appreciate it.
Sherilyn Knapp in Wellington County. I apologize because it's early if I'm not on my game about this, but on the subject of assessment, isn't it the state of the law that you can't, a client really can't get an assessment of a contingency matter if there's any interpretation of the contract required? And are there recommendations to update the Solicitors Act around that?
Sorry, I couldn't hear exactly what you said.
Isn't the state of the law that you can't have an assessment of costs when an interpretation of the contract is required, that isn't in the jurisdiction of an assessment officer.
Yeah, I think that's right, and that's not something we've addressed particularly, but I think it's a fair comment.
So that if part of the requirement is to let clients know you can get your bill assessed, then there also have to be updates to the Solicitors Act advocated for to.
Yeah, I guess you're right in the sense there may be circumstances where they can't get it assessed, and it may be a matter of fair disclosure as to what they have to do. The concept was not so much assessment, although you fairly criticized the language or critiqued the language, but it is open to the client to challenge the account is probably what is better said,
Okay, thank you.
but I appreciate the correction.
And so, because my understanding is that a contingency fee a contingency agreement that's challenged would right now have to be in the Superior Court of Justice, right? It has to be a Superior Court judge that's interpreting that. So I guess, is there any concern of what would occur if these, let's say, the challenges to the contingency fee agreement would, in a way, tie up more court time and potentially expose the client to cost consequences if they aren't successful, plus what happens in the months of delay between the challenge and the motion, because what happens to those fees that the lawyer's already waited perhaps 4 or 5 years to receive? I mean, I'm just wondering, is it just a recommendation that's kind of broad that we have to inform them of their right to challenge, and then we'll kind of deal with the fallout of that after?
Well, I guess I would say two things. The core thought, and we must believe this as lawyers and advocates, is that a right without a remedy is of no value, and if the client's right is to a reasonable fee, but there isn't a remedy and isn't information to allow them to assess that right, then something's wrong. What you're saying, I think, is perfectly fair, is that we also have to worry about the fairness of a system procedurally in which rights are adjudicated. I don't think we can ever go to a system which says we shouldn't inform people of their rights and give them information because it leads to further adversarial complexity. I agree we should be talking about that further complexity as well.
Yeah, I think one of the concerns is that the way the working group submissions were originally that we commented on, it's almost as if they were inviting the challenge. It's one thing to inform, because we have to inform them at the beginning, and I think having standardized forms would be fantastic, because I think that is really needed. But it's one thing to inform at the beginning, and they go in with that knowledge, and then to re-inform them at the end. I think it feels like, at least, that we're inviting them and not.
Well, I understand, in all proceedings where the other side is informed of their rights, it may feel like they're being invited to exercise them. Mm-hmm. I understand the way that feels, but we think if we're going to truly reform the system in a way which ensures better transparency, that's the way we need to go.
Yep. Anyone else have any questions or comments? Well, I have to say, Malcolm contacted Mike Winward and I on a Sunday. Took some time out of his Sunday. We had a brief conference call, then reached out to us on Tuesday to say I could come on Thursday. To rearrange his whole schedule to give us this update is invaluable, and I really appreciate Malcolm doing this, and I hope all of you do as well. Thanks, Malcolm.
Thank you. And if it helps, the York room upstairs is really quiet.
Okay.